All right. Hello, everybody. My name is TJ Scott. I am an estate planning attorney, a Minnesota estate planning attorney, which means that I help people to get their affairs in order so that they can be organized and so that if anything happens to them, there's legal documentation about next steps and about how the family is supposed to handle things. And when I talk about things, most often people think of things like their assets. Assets are obviously very important. But we also want to make sure that if something happens to you and you're incapacitated, that there's a plan for dealing with your person, that there's a plan for dealing with any minor kids that you have, and that somebody can step into your shoes to take care of your obligations, things like paying your bills and handling your finances. So it's a pleasure to see so many people joining here today. This is fantastic. I'm happy to be here with all of you. And please I mentioned it before. If you have a question, I invite you to share that question with me. I'd love to be able to answer it for you. And the best place to answer those questions or to ask those questions is either in the chat or the Q&A feature. And so please bring those questions to me. I'd be happy to answer those for you. We are going to go live out here to Facebook as well. That's something that I had missed up until now. But the best place to join me is live on the Zoom here because this is where I'm going to be able to see if you're asking questions. Live on the Zoom or live on Facebook, unfortunately, they're not going to be able to have that same response from me if they're asking questions, but at least we're getting the information out there. It's valuable for everybody. Okay. Enough with the throat clearing. So welcome here. I'm very pleased to have you with me tonight. I invite you right now to turn off any distractions that you have. If you have another tab open, I invite you to set it aside for now. If you have the TV on, set that aside. Give yourself this time to learn about estate planning. We have a lot of information to go through. It's fantastic information, but it's really important that you give it your attention here tonight in order to learn it. It can be a little complex at times, but I'm going to try and make it as easy and as simple as possible. And I always tell people your future self is going to be glad that you took the time to educate yourself on estate planning. And I want you to stay with me here till the end of the presentation. If you do, I have a few offers for you. I want to give you a virtual one-on-one meeting with me for absolutely free, and we'll talk about that as we go through the meeting here today. Plus, I have a bonus gift that's going to make it even easier to get a custom, tailored estate plan in place to take care of you and your family in the case that anything happens to you. So, what are you hoping to learn here today? Maybe you've done a do-it-yourself will or something like a fill in the blank type will, and you're wondering, is this going to take care of me and my family? Or maybe you took care of the estate plan, but it's been years. The kids were minors at the time, and you just wanted to make sure that guardianship was in place. Does that plan still work for you? Or is there some way that it's maybe morphed so that it's taken into account the different situation that you find yourself in now? Or maybe you just want to have a better understanding of your plan. Maybe you created this estate plan, but it's been so long now that you're just not exactly sure what it means or what it says. Or you haven't completed an estate plan at all, and you're just trying to get this information and try and figure out what's the best way to move forward. So, whatever the case is, I hope if you have a specific question here tonight that you'll share it with me. We're going to cover a lot tonight. We're going to talk about what is an estate plan. We're going to talk about who can make healthcare decisions for you if you can't make them for yourself, and what kinds of healthcare decisions are important to make sure that we cover in case you can't make those decisions for yourself. We're going to talk about guardianship for minor children. I know not all of us have minor children, but if you have family members maybe who have kids under the age of 18, this is something that's really important to know, maybe something that you can share with them. We're going to talk about avoiding court and conflict, being peacemakers. And we're going to talk about that in the context of guardianship and conservatorship, and also in the case of probate, which occurs after you pass away. And we'll spend some good time talking about probate, exactly what it is, and especially how it can be avoided if it's something that you want to avoid. We're also going to talk about who receives from your estate and how they receive and what that looks like after you're gone. So, again, we have a lot to go through. Plus, I want to cover if any of you have any questions that you want to share with me, I want to cover those questions as well. So, just make sure that you're sharing with me as you have questions, and I will get to them in due course. We want to cover all of these topics tonight, in particular with a Catholic lens. Now, this presentation is for everybody. If you're not Catholic, that's okay. We love to have you here. But I am Catholic, and there are certain special values that we take into account, some certain things that we want to examine this with a special lens. Things like the Great Commandments: love God with all your heart, soul, and mind, and love your neighbor as yourself. We also want to evaluate this with a certain respect for life and understanding that life has meaning, and we want to preserve that life if possible. We also want to understand that we have a responsibility and we have different responsibilities. We have a responsibility to God, to our family, and to our community, and that we want to carry that out in the right way. We also want to, if possible, foster a growth of virtues and look to the Beatitudes to understand what it is that God and Christ calls us to be. And we should all be striving for sainthood. And that's something that enters into the picture with estate planning in a special way that we'll talk about here a little bit. But before we get into more of the details, I want to share with you a little bit about me. So, I am an estate planning attorney. I'm located in Bloomington, Minnesota. That's where I live. It's where my office is as well. My office is here on France and 494 in the Bell Bank building, if you can picture it. I'm married, and my wife and I have 5 kids. We homeschool those kids. We're parishioners at Holy Family in St. Louis Park. And my family is really my whole world. I graduated from the University of St. Thomas School of Law in 2012. I worked really hard in law school, graduated near the top of my class, magna cum laude. I was on law review, and something fantastic happened to me the day after I commenced from law school. My son was born. And being there in the hospital room with my wife and with my newborn son kind of clarified some of my wishes about what I wanted from my law practice. I wanted to serve people. I wanted to be focused on giving value to people around me. And I was really lucky. I found an estate planning firm where I could do that. I worked under an attorney who had been practicing estate planning for something like 35 years, and I learned from her how to write fantastic estate planning documents. I also learned that estate planning doesn't stop in the four after the 4 corners of the documents have been completed. There's more to it than just writing those documents. And it's especially important that you work with an attorney who can continue to give you guidance and support for your estate plan, because estate planning requires that lifetime of guidance from a trusted counselor. So I learned all those things in that first job, and eventually came out and started my own firm, the law office of Timothy J. Scott here in Bloomington. So I told you we were going to cover what is an estate plan, and let's talk about that right now. An estate plan, I define it this way. It's a plan for your person, your assets, and those you care for in the case that you become incapacitated or for when you pass away. Most people think of an estate plan as something that kicks in when you pass away. And that's true. That's a part of the estate plan that's essential, that's really important. A lot of people think an estate plan is just for when I pass away and it's just dealing with my assets. And that's not the whole truth. That we also want to plan for ourselves, the kinds of healthcare decisions that can be made for us, what those decisions look like, and who should carry those decisions out. We also want to plan for if there are people we are responsible for or who rely on us. We want to have a plan for those individuals as well. And we want to plan not just for when we pass away, but if we become incapacitated, if we're in a coma, for example, or a vegetative state before we pass away, we want to make sure that we have the right people making healthcare decisions for us and handling our finances, doing things like paying our bills. So estate planning is kind of an umbrella And there are lots of tools that might fall under the estate planning umbrella. Things like a healthcare directive, power of attorney. More often we hear will. A lot of people think of a will when they think of estate planning, but there are different trusts that might be under this umbrella as well. Memorial instructions, beneficiary designations are under the umbrella. All kinds of things that we need to look to and tools that we need to use in the right way to make sure that things are taken care of in the way they ought to be taken care of. So let me ask you this. Do you have an estate plan? And I'm going to try and post a poll here to ask you if you have an estate plan, and we'll just see what the results are. So if you see that pop up on your screen, I invite you to engage with it and answer the question. I'm seeing a little bit of a balance, but I'm seeing more people are leaning towards no, I don't have an estate plan in place. In fact, it looks like about 3 to 1 people don't have an estate plan in place who have been able to join and been able to answer the poll today. And I really appreciate you sharing your thoughts and sharing where you are coming from here today. It's great to know. If you don't have an estate plan in place, um, it's okay. You're not the only one to be lacking an estate plan. Something like 68% of Americans have not written a will. And that's just the reality. It's pretty common for people not to have taken care of this. But the good news is you're here tonight. You are taking the right step to get this taken care of. And I really appreciate you being here tonight. The reality is everyone actually does have some kind of estate plan. If you don't have these types of documents, things like a trust, a will, healthcare directive, power of attorney, memorial instructions, most people will have beneficiary designations on things like retirement accounts and life insurance. And there is a default plan here in Minnesota. And the default plan generally that Minnesota defaults us into if we don't write our plan is a court process. And the court process is different depending on when it kicks in and what we're dealing with. But there are lots of court processes, things like probate, things like conservatorship or guardianship situations. Whatever the case is, Minnesota generally has an answer to it. And the answer is generally court and generally complicated and maybe not what you prefer. So for healthcare decisions, the default in Minnesota is a probate, or is a, I'm sorry, not probate, is a court process called guardianship. The default is a court process called guardianship, where where we go to a judge and we say, I think I should be able to make healthcare decisions for mom. And our brother goes and says, I think I should be able to make healthcare decisions for mom. And here's why. And here's the types of healthcare decisions that I want to make. And it creates this conflict in the courts trying to decide who is the right person to make decisions if we default to the general Minnesota default. This is an image of somebody, Terri Schiavo, that many of us remember. Back in the mid 2000s, Terri Schiavo was in the news and a big part of everyone's understanding and everyone's consciousness. And that's because Terri Schiavo, as a young woman, suffered a cardiac event and she was left in a vegetative state. She had a feeding tube inserted and was receiving tube hydration and tube nutrition. The husband wanted to remove those life-sustaining measures, but her parents wanted her to continue receiving those life-sustaining measures. There was a dispute between husband and parents that went all the way up to petitions to the United States Supreme Court. Ultimately, the courts found that the husband had the right to say what should happen with Terri. The feeding tube was removed, and Terri passed away about 2 weeks after that decision. Terri's case reminds us that this is important, and it's unlikely that we'll find ourselves in a situation like Terri Schiavo, but it's not impossible, and it happens every day. And if we're in Terri's shoes, if we were in Terri's case, we would want to have prepared, we would want to have a healthcare directive in place. The healthcare directive is the first document that we're going to be talking about that falls under the umbrella of estate planning. And in a healthcare directive, you can do two things. Number one, you can name a healthcare agent who can make decisions for you. And number two, you can name what those wishes are. So, number one, you're naming agents in an order that you wish to have making healthcare decisions for you. And you can also share with those healthcare agents and share with your healthcare providers exactly what types of decisions and what types of wishes you want them to carry out. There's a great document that we have here in Minnesota called the Minnesota Catholic Healthcare Directive. And again, if you'll permit me, I'm just going to put my Catholic hat on here again for a moment. This Minnesota Catholic Healthcare Directive is a front and back form that says these things about our preferences for our life. That we believe life is a precious gift from God. That if we're in a time of health crisis, we want to receive spiritual support from our community, from our friends, from our family, and we want to receive care that is ordinary and proportionate, meaning that there is some reasonable hope that that care is going to benefit us, that it's not excessively burdensome because it imposes a certain risk, pain, or cost on us. And here's a note, even if it's extraordinary care, that extraordinary care can be tried and then stopped if that's desired. Extraordinary care can be things that are even simple, things like respiration, machine-assisted respiration. But nutrition and hydration are generally not considered extraordinary care. That if a feeding tube or tube hydration will be useful to our bodies and will keep things going, will keep maintaining our bodies, the church teaches that we ought to receive that feeding tube or that tube hydration, that medically assisted nutrition and hydration. The reason that the church teaches this is that we don't want people being starved to death or being dehydrated to death. And that's really important that if the cause of death is dehydration, if the cause of death is starvation, then it's really a death that has been caused by some neglect or uh, um, some almost malfeasance, right? That we don't want that to happen. A very good priest once told me, we owe ourselves and others the basic care due to a human being. And that really was a paraphrase of St. John Paul II, that we owe to ourselves and others the basic care due to a human being. And the basic care due to a human being includes making sure that they do not starve to death, that they do not dehydrate to death. Pain relieving medicine is fine. Sometimes people will worry as a Catholic, can we receive things like morphine, pain relieving medicine? Absolutely. That's fine as long as that medicine is not administered for the purpose of hastening our death. And there's a special provision in the Catholic Healthcare Directive that if you are a pregnant woman, that you want to continue to receive ongoing treatment as long as a child is still gestating in your womb to protect and preserve that unborn life. Something else that's really important in Catholic Church teaching is how we handle our remains and what happens with our body after we're gone. So a few things that come up for this. It can be very good to have in your documents, in your estate plan, that you wish to receive an apostolic blessing at the end of your life. An apostolic blessing is a blessing that can be given by any priest. It actually delivers a plenary indulgence, meaning not only are you forgiven from your sins, but there's no temporal punishment that's due or that is required from those sins. Meaning that there's no you would go straight to heaven if you received an apostolic blessing. That there would be no purgatory required if you were able to receive that apostolic blessing. Organ donation, the church teaches that organ donation is a great gift, but it must be done at the right time. And there are questions right now about that, whether brain death is true death or not, and whether things like a heart or lungs that preserve a person can actually be donated at the right time. That a lot of times to be viable, the donation has to occur almost immediately, transplant person to person. But that can be really tricky if a person's heart is continuing to beat and needs to continue to beat until that donation can be given. It can be a tricky thing to get the timing right on that. Um, Memorial instructions dealing with the disposition of remains can also include things like a funeral mass, that the church prefers to have a mass with the body before cremation, which is now permitted by the church, although intact burial is still kind of preferred. But that funeral mass is important. Um, having the urn on the mantle is not okay. You probably see that question on there. That the church teaches that the body should be buried, or the cremains should be buried in consecrated ground, or in something like a niche in consecrated ground as soon as possible. And another thing, there's this tradition, this devotion of Gregorian Mass series, which is a series of 30 masses that are said in a deceased person's honor, close in time with their death. It's a beautiful tradition and something that you might do a little bit more research on. One thing that I want to say about this is, unfortunately, many of us have seen our kids or our nieces and nephews fall away from the church. And it's just a reality of where we find ourselves right now. That unfortunately, sometimes people have fallen away from the church, even though we might feel like we need to rely on those people to be the ones to carry out our wishes and deal with our remains if something happens to us. And that can leave us in a scary position that we're not sure if we're going to have that funeral mass carried out for us and performed for us. We're not sure if people are going to have the same values and handle our remains in the same way that we would want it to be treated. And as Catholics, we can make sure to communicate those values to the people that we love so that things are handled in the right way. But it's really important that we do that. Like I say, especially if we have family members who've fallen away from the church, it's especially important that we communicate in detail exactly how we want that to be handled after we're gone. So let's talk a little bit about guardianship. And what I like to talk about with guardianship, we're talking here in particular about guardianship for minor children, is that if you have kids under the age of 18 and you haven't named guardians for them, even if you have named guardians for them, the decision of where those kids go after something happens to you, if you're incapacitated or if you've passed away, is left to a judge. And the judge is going to make the decision based on the best interests of the child. And as a parent myself, I know that I have the best understanding of the best interests of my children possible, that a judge isn't going to have as good of an understanding of what is in their best interest, although a judge is going to try and make their best judgment. But that means that it's especially important if you are a parent of minor kids that you get those guardianship nominations legally documented so that if anything happens to you, the judge can see where you believe the kids would flourish, where you believe the kids would receive the best care. And that's really important to make sure that your wishes are carried out. So long-term guardianship is who is raising the kids until the age of 18. A few things that you should know is that children actually start to have a say in this decision at the age of 14. But again, parents, you are going to know what's in the best interest of your kids, and you're also probably going to know who would be an unacceptable option to raise the kids. I always tell people, a judge is going to decide, and if the judge decides Uncle Larry is the right person to receive or Aunt Cindy is the right person to receive, even if you know Uncle Larry and Aunt Cindy are the worst people to be raising your kids, one or the other or both, if a judge believes that it would be in the best interest of the child, that's what they may decide if they're not given that guidance from you. And this is that provision, this is that statute that details what's in the best interest of the children. As you can see, spiritual matters come into it, but as a relatively minor part of the conversation and of the decision. And this is why, again, if our faith is important to us, if we have concerns about whether our kids would be raised in the faith, making sure that you have long-term guardians named is really important. Short-term guardianship is kind of a flip side of that, that if you want to make sure that your kids never need to go into foster care, that they are cared for. If you don't come home from a date night, that somebody's able to come and stay with the kids. Short-term guardianship is also really important to legally document and make sure that that's taken care of. Let's talk a little bit about who would receive if anything happens to you. And we saw earlier in our poll a predominance of people who did not have an estate plan written. And again, that's pretty common here in America, unfortunately. Again, good for you for being here tonight and taking a step and getting it taken care of. Here in America, again, something like 68% don't have a will written. And so if you don't have a will written, there is a default in Minnesota about who's going to receive. Surviving spouse has a certain right to the assets of the deceased spouse. And then we look to the kids and the kids or grandkids, great grandkids down among your descendants is typically where the assets are going to go if you're not survived by your surviving spouse. Even if you're survived by your surviving spouse, there is some calculation and some balancing that happens between the surviving spouse and the kids. It's a little bit complicated, but it especially comes into play if it's a blended family situation and not all of the kids are from both the surviving spouse and the deceased spouse. So we're not going to get too deeply into that, although if anyone has specific questions about it, I would welcome those. I see somebody sharing that they filled out their healthcare directive with Park Nicollet in January, and that's great. It would be good to possibly to have that reviewed and make sure that it really matches your wishes. But that's great to hear that you have something in place. So after we go through kids, grandkids, great grandkids, then typically we go up. If you don't have any descendants, we go up and we go to your parents. And we say, if there are no descendants, we're going to go up to your parents and we're going to look for descendants of your parents. So that's things like siblings, nieces and nephews, grandnieces and nephews. Those are typically the next recipients who would receive. We even go up beyond that, that if it's not descendants of your parents, if there are no descendants of your parents, then we actually look at descendants of your grandparents. So aunts and uncles, first cousins, and we look through that line of succession. But I highlight this because something that is absolutely not included and that's not considered here is if you die intestate without any will, without any direction of where your assets are going to go, there is no provision for charity. And so it's natural. We want to steward our assets to provide for our kids, to provide for our surviving spouse if something happens to us. But as Catholics, a lot of us are charitably inclined as well, that we want to give to our church community. And there are beautiful ways to do this, things like endowments right now that can continue providing for your church community almost indefinitely. Truly, truly beautiful ways to give. Or Catholic schools that have had great meaning. Knights of Columbus, as Catholics, some of us are members of the Knights, or other Catholic charities here in Minnesota. Things like Pro-Life Across America, Sharing and Caring Hands, the seminary, St. John Vianney Seminary, College Seminary at University of St. Thomas, or the St. Paul Seminary as well. I did see a question here come in, and I wanted to speak to it. The question is, how about guardianship for an older person with dementia? And that's a great question. Typically, what we would hope to have in place if somebody was older and started to suffer from dementia, we would hope that we had things in place like a healthcare directive and power of attorney. Having a healthcare directive and power of attorney in place could short circuit the need for guardianship or conservatorship. But if it's just progressed to the point where that person is no longer competent in order to sign documents, then you may need to go to the court and ask for that guardianship or conservatorship. Guardianship would allow somebody to be making healthcare decisions and decisions on where that person is living. Conservatorship would allow somebody to be making decisions on finances and making sure that things continue to be paid. So those are processes that may have to be gone through, unfortunately, if planning wasn't done appropriately at an earlier stage. If that's the reality for you, or if that's the case for you, I encourage you to reach out to me and we can do an evaluation for the competence of that person, whether or not they could possibly still sign a healthcare directive or power of attorney. That a lot of times with dementia, there can be varying levels of understanding even throughout the day, there can be varying levels of understanding. And if we catch that person at a good moment on the right day, it's possible that we could still sign a healthcare directive or power of attorney that would give people the ability to make decisions about their person or decisions about their assets that could short circuit that expensive and time consuming, conflict filled court process called guardianship an adult or conservatorship of an adult. Great question. I see somebody asking a question here. Can I not include my daughter and granddaughter in my will? Absolutely. You can include whoever you choose in your will. What I'm saying here is the default in Minnesota may not have things going the way that you would want, excuse me, the way that you would want things to go. And that's where it's really important to reach out to an attorney to kind of get an evaluation. But typically, daughter, granddaughter, they are the decedent's descendants by representation. That is covering people like your children, your grandchildren, your great-grandchildren through this provision right here. If you are the surviving spouse, if you don't have a surviving spouse of your own. All I'm saying is oftentimes we're charitably inclined as Catholics, and those charities are not included unless we do some planning of our own. So let's talk about the how. We talked about the who is going to receive. Let's talk about how decisions are made and how things are going to go. And again, here in Minnesota, the default how is a court process, and they have different names depending on what kinds of decisions we're making. So if it's a decision about healthcare or where a person is living, the court process is called guardianship, or guardianship of the person. If it's a decision about finances during a person's life, the process is called conservatorship or conservatorship of the estate, or guardianship of the estate. There are various names, but conservatorship is typically the one that's used here in Minnesota. Or after death, there's a process called probate. And all of these processes, you should know, they can create court and conflict, especially if it's not clear what mom and dad or what you would have wished. And so you can pair things like the son against the daughter. There can be arguments and questions about whether you intended to have equal distributions or unequal distributions. There can be questions about whether you wanted to live in a nursing home or not, questions about whether you want a feeding tube or no feeding tube. All these different things, the court wants the people to come and make their best argument. Who should handle health? Who should handle finances? Make the argument. What should we be doing? How should we be taking care of things? And after somebody passes away, again, come to the court and argue who should be receiving and how should they be receiving. And there are certain preferences. The court has certain preferences, like giving equal distributions, but it may not be exactly how you want it to be. And that's why it's so important to empower yourself to take action so that you take care of it. So the default, again, after you pass away, the default way that your assets pass to the next generation is through a court process called probate. And in that process, we need to have an agent who can stand in your shoes in order to administer the estate as if they were you. You're not going to be able to do it since you've passed away. So we need to have an agent named for you. That agent is called an executor, or here in Minnesota, we call it a personal representative. And that the job of that personal representative is to make sure that all of your creditors get paid. And after that, so really they need to inventory your assets, collect everything, make sure they have all of the assets possible in your estate, make sure that any creditors get paid, prepare an accounting for how they've used the money, and then finally distribute out the assets to the heirs or devotees that are there. What you need to know about probate is it takes a long time to get through here in Minnesota. It takes at least 6 months to get through. More often, we're seeing it take something like 12 to 18 months. It's a long process, and it takes a lot of energy to get through. Probate's also expensive. We estimate probate to cost something like 3 to 6% of the gross value of your estate. And so, to give you a picture of what that means, if what If all that you have is your home that's worth $400,000, and I understand for some of us that's a very nice home with real estate prices nowadays, 400,000 is becoming more and more commonplace. But if all that you had was that home that's worth $400,000, already we would estimate that probate would cost something like 12 to $24,000 to get through the process. It's expensive and it's unnecessarily expensive. It's not a process that you have to go through. Probate's also public, and I have here the will of John F. Kennedy, our president, our late president. And in this will, it's very interesting because you can actually see that he gave half of the remainder of his assets. So he gave $25,000 to his wife, Jackie Kennedy, and you can see that here on this page. He also gave half of the remainder to Jackie Kennedy. But the other half of the remainder actually went to other individuals. And he actually had to go to his children an issue. But it's very interesting that he did not provide everything to his surviving spouse, that he actually split the assets, had some go to Jackie and some go directly to his children when he passed away. The good news is that court is optional. There are ways to avoid all the different types of court. We can avoid guardianship of the person by putting in place a healthcare directive where we're naming agents to make healthcare decisions for us or decisions about our person for us, and where we're able to name wishes about the kind of healthcare that we receive or what's going to happen with our person if something happens to us. We can avoid the court process called conservatorship through a power of attorney, where we can name an agent and name the powers that we're giving to that agent as well, so that it's really clear who can make decisions about our finances, who can pay our bills if we're unable to do so. And in a will, we can name an executor or personal representative, and we can name the distributions. But something that's really important to know is that a will does not avoid court. It does not avoid probate. In fact, a will has to be admitted to probate if you're relying on that will to plan your estate. But there are ways to avoid probate, and there are some great foolproof ways to avoid probate. One is by doing planning with beneficiary designations and transfer on death deeds. And I often see this when I work with clients who are DIY type individuals or just want to have the lowest cost type plan. But there's a lot of great work that you can do with beneficiary designations and transfer on death deeds. And it really depends on the type of assets that you have and how you hold those assets, whether or not that's a good planning option for you. For a lot of people, it is. Important to remember, or important to know, is that probate has a threshold, that probate's only required if the total assets in your name include real estate. So if you own a home and that home is passing without joint designation or without something like a transfer on death deed, then probate is going to be necessary. Or if your total assets, things like bank accounts, investment accounts, things like personal property, vehicles, have a total value of more than $75,000, then you also have to go through probate. But there are ways to deal with that $75,000 threshold to make sure that you're able to take things into account so that you don't have to go through probate. Again, a transfer on death deed would take care of the house. So we wouldn't be considered, that house wouldn't be considered as part of your estate anymore. The real estate is going to go based on that transfer on death deed, almost like a beneficiary designation automatically at your death. Beneficiary designations do the same thing on things like retirement accounts and life insurance, but it's less common that I see those beneficiary designations on assets like bank accounts, on things like investment accounts, although from time to time we do see that. Vehicles are more complicated, that it's pretty rare that we see transfer on death designations on vehicles, although Minnesota has allowed those transfer on death designations to happen. There is another way to avoid probate that is a little bit easier, even, and that's by fully funding a revocable living trust. And the simplest way of telling you what a trust is an agreement between two parties. One starts with property, and they entrust that party to somebody called a trustee. They say, here's what I want you to do with that property, and the trustee says, yes, I agree. With a revocable living trust, you are the person who starts with property, called the settlor or the grantor, and you entrust that property to yourself as trustee. So you are both of these people. You are the settlor, you are the trustee. And so it's easy for you to agree to follow the rules that you're writing since you're able to write the rules. It's also a revocable agreement, meaning that you can amend the agreement, you can make changes to it, you can revoke it entirely if you want to. But the advantage here is that by transferring those assets into your revocable trust, when you pass away, a successor trustee can step into your shoes right away. They don't have to go through that lengthy and expensive court process called probate. It's totally avoided. But it's really important to make sure then that you are fully funding your revocable living trust if you're creating it. And that means doing things like putting your home or real estate into your trust by quitclaim deed or some kind of transfer deed, putting your bank accounts into the trust by changing title on them so that they're no longer in your personal name. Now they are in your name as trustee. Same with investment accounts. Personal property is very easy to put into the trust. There's just a simple document that we create called an assignment of personal property. All kinds of things. We want to get those assets into your trust so that your trust governs and a successor trustee can step into your shoes without having to go through the probate process. So I will look here. I don't see any questions coming through right away, but I hope you will ask them. I understand that a revocable living trust is a little bit of a complicated planning mechanism, but it really can be pretty simple and is a fantastic way to make sure that your loved ones don't have to go through that complicated, expensive, and time-consuming process called probate if something happens to you. You're really looking at a difference here. With the probate process, you're looking at least 6 months of difficulty. With a revocable living trust, we can have things wrapped up within a month. It's that simple to take care of things. Um, okay, let's talk a little bit about estate taxes. And here is where I usually get to give people good news. Most of my clients are not doing estate planning because of estate taxes. That most of my clients are doing estate planning really to keep things simple for their family if anything happens to them, to make sure that their family doesn't have to go through court and conflict. But estate taxes may enter into the picture for you. The good news is that although there's a federal estate tax and a Minnesota estate tax, the exemption amounts for these taxes is pretty high. In fact, the federal estate tax exemption is extremely high at $13.99 million. And that exemption amount is actually portable, meaning if you have a spouse, when the surviving of the two of you pass away, you actually get to reach back and claim any unused exemption from your deceased spouse, which means you really get to double that number pretty easily, up to almost $28 million. So certainly, if you have more than $14 million or more than $28 million, that's an asset of yours, then you're going to want to reach out to an estate planning attorney. But I know that that doesn't apply to most of us. In Minnesota, we also have a Minnesota estate tax, but the exemption here is pretty high. $3 million is a pretty high exemption. And for most of us, the Minnesota estate tax isn't coming into play. Important to know is that it's more difficult to double that $3 million exemption. It's not portable, which means that you have to do some planning and you have to enact some provisions and do some work after the first spouse has passed away in order to take advantage of their estate tax exemption before it goes away. So it's very possible, it's very doable, but it is really important to know that something has to be done in order to make sure that we're taking advantage of as much of the estate tax exemption as possible. And here I want to give you a caution. As Catholics, a lot of times, again, we can be charitably minded, we can be caring and want to give to those that we see who are in need. But if you have an intent to give an inheritance to somebody and that person is on a government benefit, you should know that your inheritance may actually do them more harm than good. And this, again, is where it can be really valuable to talk to a professional, to talk to an estate planning attorney. If you give an inheritance directly to somebody who is on a government benefit, Having those assets in their name can disqualify them from certain things, things like housing benefits or things like certain healthcare benefits, and require them to start to pay down from that inheritance for those types of goods. So it might knock them out of the group house situation that they're in because now they have access to cash. They have to go find an apartment of their own. But that inheritance is just going to whittle down paying for the rent for that apartment or whatever situation they're in. And at some point, their inheritance will run out and they will have to go back on the government benefit. And that's where it really gets to be difficult. That sometimes the government benefits can take a long time to qualify for and can actually be pretty difficult to qualify for. So if that's the case, if you're giving to somebody who might be on government benefits. It's a beautiful idea. It just needs to be done in the right way through a special or supplemental needs trust at that point. We've talked about a lot of things here tonight, and maybe something here has resonated with you. Maybe the question about who would make healthcare decisions for me and how do I make sure that I empower that person to make those decisions for me is something that resonated with you. Or maybe you're concerned about your family having to go through court and conflict after you die, or if something happens to you and you become incapacitated. Maybe you have a specific idea of who you want to have receive your assets, but you're concerned because it doesn't match perfectly to what Minnesota thinks you want to have happen. Whatever the case, you might be wondering at this point, is this something that I can fix myself, or should I hire an attorney? And here's what I recommend. Estate planning is complicated. I had somebody recently describe estate planning as putting together IKEA furniture without the instructions. There are details, there are a lot of moving pieces that need to work in concert and work together in order to get the right result. And when you're putting it together, there's no guarantee that your thoughts and your logic about how you're putting it together are going to be communicated in a way that makes it easy for your family to carry out. I like to tell a story about a DIY project where I personally failed. And that was I had ordered a couple of fishing rods and reels. I was going to take my son out fishing, and those rods and reels came without fishing line on them. Not a problem. I ordered some fishing line as well, and I sat down to actually put that fishing line on the rods and reels. I thought that I had done a good job. I went and I was winding up the line on one of the rods and reels. And I went to snip it at the end, and I don't know exactly what I did wrong, but all of a sudden that fishing line started jumping off of the reel. And I had this huge tangled mess, kind of similar to what the picture is here, of fishing line on my table in front of me. I give the example of that DIY failure because that was a project that it was okay to fail at. First off, I knew that I failed like right away. Trust me, I knew that I failed right away when I had all this fishing line on the table in front of me. But it's okay because I was able to snip what was tangled and what was unusable, and I still had enough line on my rod and reel that I was able to still take my son fishing with me that same day. I was able to fix it. And all it cost me was something like 30 cents worth, maybe, of fishing line that ended up being unusable. That was okay. That was a DIY project that failed. That was okay. But the reason that I give that example is because estate planning is almost the exact opposite of that situation. If your estate plan fails, you are not going to be there to fix it. It's going to be your family trying to put the pieces together. And it's going to take a long time. They're not going to be able to fix it in a day, in a week, in a month. It may take over a year to fix issues that you weren't aware of in your estate plan. And I can tell you as well, as somebody who has needed to step in and help people to fix estate plans, it's costly. It's not going to cost 30 cents worth of fishing line. The cost of fixing broken estate plans is much higher than a little bit of lost fishing line. And so keeping all that in mind, um, Uh, it is better to not DIY your estate plan. It is better to hire an attorney. Which brings me to the next question. If you know that you need to hire an attorney, which is better? Do you work with an attorney who's kind of a typical estate planning attorney, or do you hire somebody like me? Well, a typical estate planning attorney is going to give you this experience that you're going to get form documents that are kind of set it and forget it. It may not keep the money out of the Minnesota Department of Unclaimed Property. We do something a little bit different in order to make sure that every asset that you have passes to the people that you want to receive. And we are very detailed and meticulous in making sure that it happens that way. The typical estate planning attorney may avoid probate, but maybe not. In fact, I've heard some estate planning attorneys describe the process as they get later into their practice. They describe their practice as maturing, which means that now they are where they wrote the estate plans 20 or 30 years ago. Now they are probating those estate plans, which is a second form of revenue for those estate planning attorneys. Um, that's not our practice. We are always trying to keep things simple for our clients. The typical experience probably isn't going to keep your family out of court and out of conflict. It's the sad truth that it's not a focus of the typical estate planning attorney. Typical experience is not going to leave assets or is going to leave assets to heirs unprotected. There's certain protection that you can build in to make sure that those assets aren't accessible to people like a divorcing spouse or a creditor in a bankruptcy. Typical experience doesn't provide ongoing legal guidance, and that's typically because most estate planning attorneys still charge hourly fees for the preparation of documents and for any future communication or future needs. And if you have minor kids, a typical estate planning attorney isn't going to put together a plan that's going to adequately protect those kids. It's going to leave you with this question at the end of the day. Is my estate plan going to work when I need it to work? And that's not a question that anybody should have after working with a professional. Planning with me is a totally different experience. Planning with me means you're going to have a flat fee. It's very opaque. It's not transparent, or I'm sorry, it's very transparent. It's not opaque like a typical estate planning attorney. We present those fees to you based on certain packages that you can choose so that you choose the fee that fits your family, your situation, and your finances the absolute best. Planning with me means that we can keep the money out of the hands of the state. That includes things like the Minnesota Department of Unclaimed Property. It could also include things like estate taxes or probate. Planning with me means if you have minor kids, we can plan for those kids and protect them completely in the immediate and in the long term. Planning with me means helping your family to avoid court and conflict. And this is something that is especially important to me. That at my heart, I am a peacemaker and I seek options and counsel my clients typically to look at options to keep the peace in their family. And I think that we're called to do that in the way that we handle things. Planning with me means knowing that you've made the right decisions along the way because I educate you and empower you to make those decisions. We really work together to make the decisions in the estate plan. They're not just forms that I'm foisting upon you, that I really guide you through the process so that you understand and you make the decisions in the way that you want them to be. Planning with me means protecting the family money from outsiders. Again, people like a divorcing spouse or creditors in bankruptcy. And it means a lifetime of guidance and protection because we don't charge hourly fees and we include ongoing legal questions and legal guidance with us. Now, if you want to make changes to your estate planning documents, there might be a fee for that in the future. But if you just want to pick up the phone and say, can you remind me what is the name of my trust or what did you recommend that I do with this retirement account? We are here and we are here to guide you and to be a counselor to you so that you have the right answers at that point. Finally, planning with us means that you know your plan is going to work when your family needs it to work. And that gives so much peace of mind. It is such a weight off of our clients' shoulders, and we hear that all the time. It's a beautiful gift that you're giving to the people that you love. So I encourage you to reach out to me, and I'm going to go ahead and share my booking link in the chat right now with everybody. I really encourage you to pull up that link, and you're going to see, unfortunately, I don't have any additional meetings available in June right now. I am booking out to July, but I have great availability in July, and I really encourage you to look at my calendar and find some time. What I want you to look for in particular on that meeting link is for the family wealth planning session because it's a free meeting that I want to give you. It has a $750 value because I set aside 2 hours of my time for that meeting. It's a meeting where we get to talk in specific about the things that we talked about here tonight. So we will talk specifically in your family with your assets. We will talk about how we can make sure that we protect the people that you love and the things that you have so that things go the way that you want them to and that you're taken care of in the way that you want to be taken care of. But I want to give you that meeting absolutely free. And in the first hour, we're going to talk about where you're at right now and where you want to go. What does your ideal estate plan look like? And then we'll talk about the different estate planning tools that we have that we can use to help you get from where you are right now to where you want to be. And talking about those different tools will tell us what kinds of fees we may need to charge in order to put that estate plan into action for you. So after that first hour, we'll present to you different estate planning packages and we'll help to coach you and guide you in choosing the estate planning package that fits your family, that fits your situation, that fits your finances the absolute best. And if you choose to move forward with us, then we will give you $250 towards that estate planning package of your choice. But there's a time limit on that second offer. That if you want to secure that $250 towards the estate planning package of your choice, I need you to reserve your appointment before the end of the week. And that means the end of the day on Saturday. And the reason that I need you to do that is this that if I don't hear from you, if you haven't booked your appointment, and I really encourage you to click through and grab one right now, even if you need to clear dates with your spouse or a significant other or somebody before completely confirming, I really encourage you to move forward and take this next step to get this family wealth planning session on the stage. But the reason that I'm willing to give you that I'm happy to give you that $250 towards the planning package of your choice is because I will know that you have kept the momentum going and that you're ready to get an estate plan written. That what I see happen a lot of times is estate planning is something that gets onto the to-do list, but it rarely gets checked off. It typically falls down, among all the other tasks and responsibilities that we have on any given day, on any given week. And because of that, it typically doesn't get checked off. It just ends up falling off the bottom of the to-do list. And I see that happen a lot, that people will come to my presentation and if they don't book immediately, maybe they say, I'm gonna talk to my spouse and we'll find a time. Or maybe they say, I just need to check my work schedule and make sure this is gonna work. Or maybe they say, I'll get it scheduled in the fall when the kids are back in school and I'll feel like I'm ready to schedule then. And those are all good wishes. They're all perfectly reasoned, logical decisions. But what I see is it doesn't happen. That it ends up on the bottom of your to-do list, and at some point it's going to drop off. And so I encourage you to take care of it right now. And the reason again is if you don't do it now, I will follow up with you and I will continue to touch base with you and say, hey, you came to my presentation. I know that this was important to you at one point. What is it going to take in order to get you to register with me and move forward with me? And at that point, we wouldn't be offering the $250 because we would be taking extra actions. There would be an added cost. There would be an added hurdle for us to continue reaching out to you and continue encouraging you to move forward. Which again is just why you can simplify things right now by getting it booked now, getting it booked today so that you already have it taken care of. You know that you're taking the next step. So I have another question here that I want to get to. In the meantime, I'll let you continue to read through the presentation and read some of the reviews that I've received and some of what my clients have said about working with me. But the question that I see here is if I designate my brother who's on Social Security and Medicare as a person to whom my estate would be given, will that result in him not getting Social Security and Medicare? And that's a great question. Social Security and Medicare are not asset tested. They're not income tested programs. That Social Security is taxable at some point if your income increases, but I wouldn't worry about leaving an inheritance to somebody who's receiving Social Security, receiving Medicare. What I would worry about is if that person is receiving medical assistance, we call it here in Minnesota, or Medicaid is the other name for it. That if they're on a Medicaid or Medicaid type program, or if they're receiving housing support, those are the situations where we have some concerns that it may disqualify them from a government benefit in order to receive it. So if your brother is on Social Security, if your brother is on Medicare, that's not a problem at all. That's really normal, and it's really normal to receive an inheritance in that case. But if he were on Medicaid, or if he was in a nursing home and receiving long-term care, or on something, a program like Elder Waiver, then we would talk about different options that we would talk about not having him receive that way. I see somebody asking here, does a revocable trust need to be filed someplace with the courts or government? And that's a great question. The answer is typically no, that a revocable trust is a private way of planning. It doesn't have to be filed publicly. The only exception to that is if there is litigation that happens because of it, if somebody sues because the trustee they think the trustee isn't carrying out the wishes in the trust in the correct way, or they have questions about how the trust was created, then it's possible that it may need to be subjected to some type of court or government process. But we almost never see that. That typically what happens with the revocable trust is a trustee administers it. They administer it quickly and accurately, and like I say, they can administer it within about a month, and have everything resolved within about a month of somebody passing away. It's really fantastic and a really great way of taking care of things in a private way, and in a way without conflict and without upset. So great question. There's a few more reviews here that you can kind of preview and see again how our clients have enjoyed working with us. So again, the next step here, if you haven't taken the time yet, I really encourage you to click over to my link, look for Family Wealth Planning Session. That's the next step in our conversation, and I really encourage you to get that booked tonight. I will be sending a follow-up email to everybody, and that follow-up email will include the link to my calendar. It'll include the recording here. I expect to have that email out to you tomorrow morning. It takes a little time to process the video. It takes a little time to uh, uh, get the email formatted and everything. But I do want to get that email to you as soon as possible, so that if you want to, you can review the recording and dial in and focus on a specific thing that we were talking about at some point. Or if you haven't taken the time to click on the link, that you'll have that link handy. But this is really the best time to click on the link and take care of everything. So I really encourage you to get it taken care of and keep moving forward, keep the momentum going, so that you will get a great estate plan written, that you have taken the right steps. I will take, if anyone else has any questions, I would love to answer them. I'd love to respond to them. Now is a very good time. So please, if anyone else has any questions, I encourage you to bring them forward right now. I'm not seeing any additional questions at the moment. I know some people have already clicked through and already confirmed their appointments, and that's fantastic. I'm looking forward to meeting with those of you who have taken the time and looked at your calendar, looked at my calendar, and found a great time to schedule a follow-up meeting. Again, I want to give you that family wealth planning session absolutely free. I want to give you a $250 discount towards the estate planning package of your choice. I want you to get this done. It's been on your mind, it's been on your shoulders, it's been occupying your consciousness for too long, and it doesn't need to. You can have peace of mind about your estate plan. You can have peace of mind about if something happens to you and you become incapacitated, or if something happens to you and you pass away. And the reality is, we all know, memento mori, right? We all know that someday our ticket is going to be punched, right? That at some point we are going to pass away. And what we do now is going to make a big impact on our family and on our loved ones. You can write a great estate plan, and I want to help you to do it. But you have to take the next step. You have to reach out to me. We have to continue moving forward so that we get things taken care of for you. So I don't see any other questions coming through. Thank you, everybody, for being with me here tonight. I really appreciate it. Thank you for giving me your time and attention. Hopefully, the information that I shared with you was really useful and that you have some takeaways here today. I appreciate those of you who have already booked an appointment. I'm looking forward to having a chance to meet with you and discuss your particular situation. And I look forward to meeting with those of you who haven't yet but will schedule a time with me. If you have any questions following this, please reach out by email, book a meeting with me, either the family wealth planning session, or if you just have a few questions about the best way to move forward, there's a link on that link as well for 15-minute phone consultations. I'd be happy to start our conversation there if that feels like a better fit to you. But I really encourage you take the next best step. Thanks again, everybody, for joining me, and I hope that you have a great evening here tonight.